All right, well, welcome. We've got another episode of free legal advice and other bad ideas. Gene, it's good to see you again.
Good to see you too. It's exciting.
I'm liking the regular visits that we get now that we're doing this podcast.
This is great. My weekly highlight.
There we go. And we'll certainly welcome everybody that's tuning in, either live or more importantly, since we're in the beta testing phase still a little bit, obviously watching this probably on tape. And we should tell everybody from the get-go, it is free legal advice and other bad ideas. So if you take what you learned from us today and you act on it without hiring a lawyer to help you with the situation, that's a really bad idea. Don't you agree, Gene?
Absolutely. This is the fine print that we need to put right at the end of every podcast or beginning of every podcast.
Beginning and maybe the middle as well.
And maybe not so fine.
Right. And, I think that's the perfect segue in when we talk about that we need this caveat at the beginning is, Gene, with a little assistance from the world of AI, from the chat GPT, what we want to talk about today is the mistakes we see clients make before they get to us. And, I commonly will be talking with somebody on the phone and I always use a 10X. I'm like, well, you can pay a lawyer $2,500 on the front end, or you can pay a lawyer $25,000 on the back end, right? Because if you're doing these things, especially if you're signing anything without having it reviewed by a lawyer or at least critically looking at it, you could be putting yourself in a very bad position when things go wrong.
It's much harder to clean up a mess than to prevent it from the beginning, and that's and much more costly to do so as well.
Right. It can go into all those cliches, right? An ounce of prevention is worth a pound of cure.
Yeah, and sometimes you can't cure it. So
yeah, sometimes it does become uncurable. And, look, I recognize too, though, that we're talking about something that's difficult, right? I mean, how many things do we all sign in our regular daily lives? It doesn't make sense to have a lawyer review everything that you're signing, right? And I think, you can look at some rules of thumb. Well, if you're signing something with $500 at stake, well, it wouldn't be worth paying a lawyer $2,000 to review it, or $500 to review it for that matter. But when you're talking about signing a contract to redo your pool for $75,000, having a lawyer look at that contract before you do it is no different than buying insurance.
Right. I just had somebody come up to me yesterday and said, "Hey, Gene, I got to ask you a question. I have a friend, and he's getting a divorce."
Always the friend.
Yeah, he's getting a divorce, and they've agreed upon everything. Can't they just do it themselves? I'm like, well, can they? Sure, they can. Is it advisable? How much of a risk taker are you? It's going to be one of those situations where once it's done. And if it's done wrong, it's going to be very hard to fix. So do they want to hire an attorney and make sure that it's done correctly, or take chances? And it all comes down to gambling. Are they a gambler or not? And I don't know if you want to gamble away your divorce that way. Yeah.
Well, and we, since we're doing a lot of family law these days inside of the firm, I'm getting that a lot. We're probably 1 to 2 calls a week where somebody's coming in and saying, well, we've agreed on everything. And I'm like, well, the first question I always ask them, I'm like, how do you know you've agreed on everything? Well, what do you mean? I go, well, if you don't know all of the things that you need to agree on to have a good divorce settlement, how do you know you've agreed on everything? Right? And that's part of what the lawyer can do for you in that situation is identify those issues. Doesn't mean that it needs to become a contested divorce. You don't even need me to be the representative in the divorce and dealing with your significant other. You may just need me in the background as an advisor to go, hey, this is something that I don't see in your agreement that's required by the court, or maybe it's not even required by the court, but it's a good idea.
Right, and they don't know what they don't know, and they think the judge is going to help them, and the judge is not necessarily going to help them.
No, and you don't want to be in a situation where, look, if you say you have everything agreed on and it checks the boxes with the judge, he's going to sign off on it. Now you have an order. And if you didn't mention to the court that there's a 1965 Mustang that was bought during the marriage that you and she agreed you get to keep because you're the one that polishes it every day, well, if that's not in the agreement and then afterwards she says, no, well, it's titled in my name and I'm not transferring the title, you don't have an order that's going to move that. So you're out of luck. And that's just obviously a myopic example of it. But that's probably my biggest thing is once you've signed something, you can't walk it back.
So on that note, you're talking about me using ChatGPT earlier to come up with some topics, and this is a great segue into that. So what are some of the things that biggest legal mistakes people have made before coming to see you?
Yeah, I'd say the biggest one is not recognizing that there is no attorney fee provision in a contract. That's probably the one that I have more conversations, and they're disappointing conversations for me and for the person that's calling, because it doesn't make sense for them to hire me. So I'm disappointed that they're not paying me any money. And it's disappointing for them because I'm telling them that I've got a $10,000 solution to a $7,500 problem. It just doesn't work. I just had a call yesterday. Interesting. The guy said that he's been in construction his whole life, but he's now retired. And he was having something redone. I think it was a pool. I don't remember. It's not really important. But he was having something redone related to tornado damage, right? And it was a $9,000 dispute. And I'm like, well, is there a fee provision in the contract? And he said, no, I've looked at it. And I'm like, well, if there's no fee provision, then whatever you spend on me is a lost cost. And I use that phrase with people all the time. Well, what do you mean? It means whatever you pay me, you're not getting back. Well, that doesn't seem fair. I agree with you. And then usually, Gene, it launches into a 5-minute conversation about how the system doesn't work for the benefit of a consumer or otherwise. And I'm like, it feels like I'm in the situation where I'm somehow responsible for the system not working the way that it's supposed to work.
People have to protect themselves, and if they don't know, they have to ask people that do know, or they're going to be in the same position. And I guarantee you that the next time that person writes a contract, they're still not going to put an attorney fee provision in there because they're not going to think about it at that point, and it's going to keep happening and happening.
Yeah, and so that's my biggest thing, is signing something without understanding what you're signing.
And it's the same for me too. Typically, I think the worst thing people can do when they come to a personal injury attorney, they come to me, they have a great case in terms of liability, they're really hurt, we can help them out, there's insurance available. And I read a letter to the insurance company, and they write back saying, oh, by the way, we settled with your client 2 months ago and paid him money, and he signed a release. No case.
And not real money.
Yeah,
$2,200.
Yeah, well, if that. Yeah, $500 sometimes. Yeah. And the client comes to me and says, well, they just told me that was for my medicals. Well, did you read what you signed? It says you're releasing them from everything from the beginning of the world to today.
Right? From the beginning of time till now, you are releasing them, and they're insured, more importantly, right? Because you don't reach an agreement with an insurance company. That agreement is actually with that other driver and their responsibility. But yeah, how often do we see that?
What turned into, well, from a really good case where I could have gotten them good compensation for their damages, they now walk away with nothing because there's nothing you can do at that point.
Yeah.
You can't, I mean, it's very, very difficult, if not impossible, to overturn that.
A little easier in a family law context, right? Because we're in a court of equity until it's an approved order. What is able to be contracted and what isn't. You can't contract without the approval of the court what you're doing with time sharing. Can't contract without what you're doing with child support, but you can certainly contract what's going to happen with that 1965 Mustang.
Right, and if you don't know what you have to address, you're going to make a mistake.
Absolutely. And that's one that we get in family law all the time too. We've worked out all of the details, and we need a lawyer to help us both across the finish line. And I know there are lawyers that do that. Where they'll represent both parties, essentially representing the deal. I've just never found a way to do that effectively. I don't know if I just don't have the skill set maybe at the end of the day, or maybe it's the temperament or appetite that I don't have for it. But I feel like when you're in that situation, I've got to know who I'm representing in the deal in order to do it.
Well, no matter how friendly a divorce might be, it's still adversarial. I mean, it's one person not getting along with another that wants to divorce. So somebody may get something that something more than what they expected, and somebody might get less. And it's hard to represent two people in that situation.
Yeah, and I feel like in the conversations that we have on a regular basis, right, I'm talking to people about what's your best day in court, what's your worst day in court, right? A good settlement is somewhere in between the two. Right? If you're having a settlement agreement where you're like, I want my best day in court, you're probably not having a settlement agreement. Right? If you're agreeing to something that's worse than your worst day in court, that's probably not a settlement agreement you should be agreeing to.
Well, a lot of mediators say this. I don't necessarily agree with it, but a successful mediation is when both parties walk away unhappy. That's typically what happens.
And it's not true in every situation, but it certainly has some merit when you look at it in that aggregate, part of it. Somebody's got to be willing to take less than what they want, and somebody's got to be willing to pay more. to a certain degree.
I mean, it's a business decision at that point, and people might have a lot of emotions involved. But when the end of the day comes, it's a business decision. Is it worthwhile getting this resolved now for this amount of money, or take my risk at trial and see what's going to happen? Which 9 out of 10 times you kind of know what's going to happen.
Yeah,
Only 9 out of 10 times, and maybe not 9 out of 10 times, but
better
you really
than
never
half,
know.
maybe some down that. Yeah, and the other one that I see on a regular basis in the civil context is starting a business with a partner without the right documentation. You know, I call it the exits on the airplane, right? If you're getting into a business relationship with somebody, you know, to do something in the honeymoon phase, right? Everybody's on the same page. We got this great idea. We're going to launch this terrific business or otherwise, but nobody talks about, well, what happens when one of you doesn't want to do it anymore? What happens, you know, in the worst case scenario, it's kind of ironic to think of, but the worst case scenario is if you think you have problems when you're not making money, wait to see the problems you'll have when you start making money. Because once you start making money, somebody will feel like they're not getting their share, they're doing more of the work. So you have to put in those original documents when you're starting that business, how this works. You know, what happens when you start making money? What happens when somebody gets a divorce? You know, what happens to their interest in the business? Do you want to be in the business with their wife at that point or their husband? You know, those things have to be contemplated. And that's where I use that analogy of exits on the airplane. You don't ever want to use the exits on an airplane in flight, but they go through them at the beginning of the flight for a reason. Because in the unfortunate circumstance where things don't go the way you want them to go, you got to know how to get off the airplane.
And people wonder why attorneys' contracts are so long. I mean, because we have to address all these things. I mean,
because we've litigated.
Exactly.
Because we've litigated over things that didn't have that term in it, right? When we weren't specific.
And like you said, people never think something's going to happen at the beginning, but when it does happen, you want to be able to find, you know, paragraph 72A that's going to address that situation. It's
100%. And, you know, with the caveat of, look, there are still situations that no matter how long your contract is, no matter how long your operating agreement is, you can't contemplate everything, you know, but you can certainly contemplate the things that we see every day, people coming through the door, you know, with these problems.
And with experience, those things that we couldn't contemplate will definitely make it into the next version of the contract. That's for sure.
No question, right? It's an evolving document. And I would say that's one of the things, Gene, too, in this new AI world, as you know, we've talked about on the previous podcast that we've done too, that we're relying on it more. Obviously, everybody's relying on it more, and it can be a really effective tool, but it doesn't finish the job.
No.
Right?
It's not a replacement.
No.
It's a helpful tool, like you said, but it definitely does not replace experience.
Yeah, and if you're entering into agreements that you pulled off of ChatGPT, they might be right. They might be perfect, but they might not. And when they're not, it gets really expensive to figure them out. And that's where you need the insurance, right?
Well, for me, talking about insurance, I know you're talking about the contract and all that, but for me, another issue that clients have when they come to me is not necessarily their fault. I actually do blame some of the insurance agents that are selling insurance, but so many of them don't have the proper coverage. I ask them, I say, you know, what type of coverage do you have? Do you have this type of coverage? I have full coverage.
Yeah.
Well, if by full coverage you mean the minimum required by law, then yeah, you have full coverage, but you don't have X, Y, and Z, specifically uninsured motorist coverage. And we were talking before about, you know, will these clients learn a lesson for the next time with, you know, say the attorney's fees provision? Right. So many times I have clients that come to me, they don't have the proper coverage. Unfortunately, I can't help them out.
Still have never gotten UM.
And they come for a second accident and they don't have the UM on it. And it just blows my mind. So there's only so much you can do.
Well, and I always tell folks when I get that full coverage, you know, comment, I'm like, so if you were in an accident and you hurt Jeff Bezos, your insurance company is going to pay out $87 billion? No. There is no such thing as full coverage. It doesn't exist. You can have good coverage. You can have ample coverage. You can have coverage that's very effective, but there is no such thing as full coverage because you can't cover every eventuality.
And in Florida, the minimum is like nothing. I mean, there's really no coverage for you. No uninsured motorist coverage, no bodily injury coverage. So the person driving on the road could legally be driving without any liability coverage to pay for your injuries. That's why it's so important. But the insurance agents don't tell people they want to sell policies. They don't want to jack up the price and say, hey, well, you can get this, but it's this much more. They want to sell the policy, so it just gets sold, and they have very limited coverage. And people don't know enough to ask, I guess.
No, and I don't think the agents are asking the right question, especially if you're going direct as well. And look, we can't throw it all on the agent, right? You are the buyer, so you have some responsibility in it too. But essentially, I tell folks, when you're looking at insurance, you have to have enough insurance that it's not worth suing you. They're like, well, what does that mean? Well, what do you have? Right? I'm like, did your insurance agent ask you about what assets you're protecting with your insurance policy? Oh, no, they never asked that question. Well, how do you know you have enough insurance? If you're a 19-year-old kid with nothing, $10,000 might be enough to cover you. But if you have assets, if you have, things to protect, 10 grand isn't going to do it.
Right, but that same kid that doesn't have assets to protect, and 10 grand might cover him if he's at fault for an accident. He could be severely injured by somebody else who only has 10 grand or less. And he needs to protect himself and have higher uninsured motorist coverage, which you really can only get if you have higher bodily injury coverage. So it works both ways.
Yeah, the law does have that part in it, which is pretty smart, right? You can't buy more uninsured motorists to cover you than you're willing to give to the general public to protect them.
Right.
Not a bad concept. I'll at least give the legislature some credit for getting that, that one right. But yeah, I'd say, when we're identifying the biggest mistakes that people make before they get to us, on your side, on the PI is certainly not having good coverage.
Right. It's funny. I guess it's the same advice I give my kids, Go out, have fun, but don't be an idiot. So you can not know everything about all areas of life, but just don't be an idiot. Do the research. When you're buying something you're spending money on, do a little bit. You have computers, you have ChatGPT, you have Google. You can do a little research yourself and find out what you need.
Well, and with our kids, they have us.
Yes.
I just had this. I'll leave the name out, but hopefully he's watching so he can understand. It would happen to be a significant other of one of my children. And by using the pronoun he, they should be able to figure this out. But it's, hey, I need to get out of this lease. Well, when did you sign this lease? 5 days ago. Well, why do you need to get out of the lease? Well, because I found a better place. Like, well, that's usually not a legal grounds, but you have access to me as a free lawyer, at least to some extent, and you don't call me before you sign. What are you thinking? Right? I mean, use your head a little bit on that. If you have questions on what you're signing, who do you need to ask that question to? And if you know a lawyer, I mean, I know I give out a ton of free, time. I won't say advice. There's the fine print caveat again, right? But I'll spend some time with folks and, give them the idea. Sometimes it's not the answer they want, right? Like, I'd have to review the contract and you'd have to pay me money for my time to do it. But no, I don't recommend signing that contract until you understand what's in it.
I mean, even if it's not specific questions, especially my kids, like you were just talking about, let me read the contract first. My kids sign stuff all the time, and they say, oh, by the way, I signed this contract. I'm like, don't you think maybe you should have just let me read it first? I'm happy to do it. No charge, obviously, my kids. But no.
Yeah, maybe Dad should have been given the opportunity as a lawyer to read the 97-page lease that you just entered into, right? That says there's no way you can get out of it, and they could put a bum in the other room in your 5-bedroom apartment. Yeah,
which they can do in a lot of these leases, unfortunately.
Well, and that, that's the recognition that I think folks, kind of don't, I wouldn't say they don't realize, they don't think of the question. Well, if you're signing a contract written by the person on the other side of the deal, do you think they wrote it for your benefit, or do you think they wrote it for their benefit? Contractors are the ones that I see on a more regular basis now than I've really ever seen. Right? Why do you think that the contractor didn't put a fee provision in this contract?
And every one of those contracts has a paragraph that says, I've had a chance to fully read this contract and have my attorney review it, and I agree to everything in it, and understand that if I didn't, it's on me. And
I waive every defense that there is on that. Right? Yep. Yeah, because the contractor knows at the end of the day, right? Because the contractor, if he's not getting paid, can put a claim of lien on your house, and he can collect fees for going after that claim of lien. So if he knows he didn't do it right, he doesn't file the claim of lien, he might not be able to collect his last bit of money, but he's also not exposing himself to the potential mistake. Yeah. And they know exactly what they're doing in that, because generally they've talked to a lawyer that's drafted that contract for them, and that lawyer has put in the provisions that, are important for them.
And they know if they make it really long and complicated, people aren't going to read it. So you need to hire an attorney to do it for you if you're not going to do it.
Yeah, which this one you can take as the free legal advice that, you know, you can certainly rely on. Okay, I didn't read the contract is not a defense. That is not your get out of jail
A lot of
free
people
card.
think it is, though, unfortunately. But
Yeah. I had with a very major builder whose name I won't mention because they litigate the heck out of cases and I don't want them litigating against me based on what they hear here. But it literally had in a contract to build a house, it had a waiver of habitability. So you were waiving which the government did put in place, right? So there is, actually, I don't think it's by statute, but there is an implied waiver that when somebody builds you a house, you can live in it, right? That would seem to make sense,
yeah.
right? And that is an enforceable right, but not if you waive it, you know. And we took that case to court fighting that clause as an unconscionable clause, and we did get a victory on that one. So I was very happy that the court did see that, hey, that's a right that nobody should be able to give away, but that's pretty rare. I mean, that's very rare. The law clearly provides that you have the right to waive almost every single right that you have,
And
with limited exceptions.
And that can really affect you too with the contracts or releases that you're signing, waivers. Read what you're signing. That's the most important thing.
And if you don't read it and don't understand it,
ask an attorney.
right?
Yes.
You know, ask somebody and get some advice. It's a cheap insurance policy, you know, to do on that side. Right. You know. The other thing I would say, if we were looking at, you know, the biggest mistakes that people make, you know, before they come to me is, and I get this a lot on our free consult calls, is coming to a conclusion before you've talked to me, right? Like if you're coming to the conversation with, I know that it is this, what am I doing? Like what advice am I giving to you if at the end of the day you've already made the conclusion that you want? Are you calling me just so that I can agree with you? And then interestingly, the people will argue with me. I'm like, I'm literally giving you my free time and telling you what I think, and you're telling me that I'm wrong.
Right. I love it when people hire you because of your expertise and then don't want to listen to what you say. It's like, if I hire a plumber, I'm not second guessing how he's doing my pipes. You know,
Right.
He's the expert, you know.
And, you know, on that vein, right, like, and I encourage my clients, and I'm sure you do as well, I have no problem with questions. You know, I like when you know, giving your plumbing example, right? Like, hey, why are you routing the pipe that way? Now, I don't have a problem with people asking me those questions and getting an explanation because I want them to have the peace of mind that we're making the right choice. But when I tell them and then they disagree with it and then they don't want to follow my advice, well, that leads to the next conversation, right? Which is, well, let's talk about what happens if you don't follow my advice or what could happen, right? And that's, you know, you always hear the kind of the phrase, you know, that attorneys are deal breakers, not deal makers. You know, that's kind of a common phrase in the transaction world. It's not that we're trying to break the deal. It's that we're trying to make sure everybody understands the deal they're getting in.
That's it. Just clarity. Everyone knows exactly what it is, and they're signing off on it. No ambiguity, and that's why everything is unfortunately so long and detailed, because we want to make sure everything that we can think of is addressed and that is conveyed to both parties.
Yeah. Make sure what's in the release, which, yeah, you'll like this one, Gene. So I'm in a debate. Not a debate. I think at this point it's an out-and-out fight. So settled a PI case. Person's on Medicare. Settled for a certain dollar amount. No caveats on the settlement whatsoever. And now they want to issue the check to myself and Medicare. And I'm like, are you kidding me? Do you know what it would take for me to get Medicare to sign off on a check to get it deposited?
And it's not even required. I don't know how these insurance companies think that this is part of the law. I mean, in the release, it already says we're indemnifying them, the clients indemnifying them for anything.
We are.
Yeah, it's just ridiculous how they want to make it so difficult.
Right. And do they really think that you and I are going to put our bar license on the line over a $5,000 or $6,000 Medicare
Exactly.
lien? I mean, the law is very clear that you and I have a responsibility to Medicare as well. We can't stiff Medicare.
And it also wasn't part of your deal with them. You settled the case. It didn't say contingent upon us writing the check to Medicare. You know, it's
They even wanted to take it one better. They even wanted to take it one better and say that if we were able to reduce that lien amount, that then it would reduce the total amount of the settlement. I'm like, okay.
This
then
is
why-
ongoing now?
Yeah. Yeah.
Oh my God.
And the check was supposed to be sent last week. And I got a client, you know how that goes,
Yeah.
right? Once we say that a check's on the way, you get the call every day. Where's my check? Where's my check? Where's my check? And I don't blame the client, right? They have an expectation that side. But, what I fired back to them in the conversation, and their lawyer is on my side. Like, he's like, I get it. I understand exactly where you're coming from. But I'm like, okay, well, so if I don't get the other doctor's bill in here reduced, are you going to pay more? That's the way we're doing. So if it's good for the goose, let's go for the gander, right?
Well, I'm very interested to hear how this plays out because I've always been able to resolve those. Some insurance companies have given me a hard time about that before, but we've always gotten it written out directly to our trust account. So we'll see what happens. Wow.
Yeah. Or are they going to give me back the 6 hours on the phone that I'm going to spend with my client for the next
good
2
luck on
weeks
that
as they
one.
keep saying that they want their check, they want their check? Oh, it's baffling in that side of it. But those are the situations, those are the nuances, those are the details that as a non-lawyer you wouldn't recognize, because who would want to recognize it, right?
These are things that keep me up at night too.
Yeah, 100%. And that's what goes back to kind of the theme of what we talked about, on today's podcast is, what are the mistakes you're making before you get to a lawyer, right?
So many more are going through my head that this could be a whole hour episode if I were to bring them all up. But
it could certainly drag on from that. But yeah, at the end of the day, I think the advice, the non-binding advice that Gene and I have no responsibility to you for as a listener, because it's free legal advice and other bad ideas, is, look, the earlier you get a lawyer involved, usually the cheaper it is. I know it doesn't feel that way. And I know certainly you're thinking that, why am I going to spend $1,500 or $2,000 on a lawyer to look at something, in that side? But man, it's that 10X factor. That $2,000
well
can save
spent.
you 20.
Yep.
Yeah, no question about it. So, well, we hope everybody picked up a couple of gems in our podcast today. We're really excited to be doing this on a weekly basis. And, if you're watching us on one of your various platforms that we're plastering this out on, send us your questions. We would love to hear from you and answer some of the trickier ones. And we can't promise that it'll be good advice. We can only promise that it'll be free advice. And we can only promise that it might not be a bad idea at the end of the day. But we'd love to have that feedback. And the more interesting, the more crazy is probably better for the content. So send us your questions. We'll be happy to answer them here on Free Legal Advice and Other Bad Ideas.